Hello everyone. Welcome to the second of the RISA, BVI and BVI Finance webinars on insolvency. We have an esteemed panel this afternoon, if I can just introduce the participants. First of all, Carly Human. Carly is a South African qualified attorney and business rescue practitioner, specialising in corporate recovery and insolvency. She forms part of a larger Begbie's team, which takes IP appointments offshore and in the UK. And she joined the BVI with a wealth of insolvency and recovery expertise gained at top-tier accountancy firms and financial institutions in South Africa. Second, I'm joined by Shane Donovan. He's a partner at Marant with over 10 years experience of BVI practice. And prior to that, he practiced in London and in Australia. We're also joined by Lisa Walmsley. She's a partner in the Bedell-Christian BVI partnership. And prior to that, Lisa was a barrister for some 20 years, specialising in insolvency law. I'm David Harby. I'm the partner and head of Collis Krill's dispute resolution and contentious insolvency team. So today we have a webinar to deal with the subject of creditor-focused insolvency. You will see the topics that we're going to cover there. There are 6 of them. I'm going to deal, first of all, with basic concepts that every creditor, indeed every practitioner, should know, which should inform the rest of the webinar as we go forwards. Shane is going to deal with security and enforcement in the BVI. Carly is going to deal with the first meeting of creditors and the formation of a Creditors Committee. And Lisa is going to deal with topics 5 and 6, the removal of a liquidator and challenging the liquidator's decision. So having said that, without further ado, let's go on to the first of the topics. So the first slide you'll see there poses the question, who is a creditor or who is a secured creditor? And it's important that these definitions are worked through, particularly within the context of a typical contentious insolvency, because effectively they govern who has standing, as we'll come on to talk about in due course. But just by way of a preliminary point, it's important to note that at its heart, a liquidation is a form of collective remedy in which a liquidator collects in the assets of a company, realises or sells those assets and pays them out at a rateable proportion to the creditors. Those persons who are deemed creditors for the purposes of the Insolvency Act, in particular Section 9, are set out in that slide. There's just a couple of points to make. The first is one can see that when we're talking about the general definition of a creditor, namely a person is a creditor of another person, the debtor, if he or she has a claim against the debtor, whether by assignment or otherwise, that is or would be an admissible claim in a liquidation of the debtor company. When we're looking at that definition, it's important to have regard to the fact that whilst the creditor must have a claim that exists as at the date or as at the relevant date, the material time, for example, an application to appoint a liquidator, it doesn't necessarily need to be immediately enforceable. By that I mean that the claim could be, to have standing, enforceable in the future, or indeed subject to some contingency that may need to be fulfilled in the future. And secondly, it's important to note that that general definition of creditor also encompasses claims where the quantum or the value of that claim has yet to be ascertained. You'll see the second 2 limbs, so just go back to that slide again, Shane. There you'll see that an unsecured creditor is broadly defined as a creditor who is not a secured creditor. And just having regard to that definition, it's interesting to note that generally speaking, the Insolvency Act is geared towards the protection of secured creditors, but there are a few notable exceptions. And in particular, it's important to note that where a liquidator recovers sums relating to fraudulent trading or insolvent trading, it's often the case that they're ring-fenced in favour of unsecured creditors pursuant to section 257 rather than secured creditors. So there's a general rule. Insolvency is geared towards the protection of secured creditors, as we'll see, but there are a few notable exceptions. Okay, the next slide. Thanks, Shane. So in order to have standing, in effect, you need to show that you have an admissible claim, and that's defined broadly in section 10 and section 11 of the Insolvency Act 2003. You'll see that the definition there, however, really relates to balance sheet insolvency. That is where a company has more in the way of liabilities than it does in the way of debts. Balance sheet insolvency is one of three types of insolvency tests that apply in the BVI. The other is cash flow insolvency and technical insolvency. In relation to cash flow insolvency, generally speaking, you're having regard, rather than liabilities in a broad sense, to debts, and those debts are effectively crystallized sums of money that are owing to the company. And it's important to note that if you're looking at cash flow insolvency, namely whether or not it's possible for the company to meet its debts as and when they fall due, you can't have regard to future or contingent debts. Next slide, please, Shane. So what is what is a security interest under Section 2 of the Insolvency Act 2003? What effectively gives you standing as a secured creditor? Well, the definition includes a charge and a lien. The first of those is effectively a right to sell an item or an asset, and the second is a form of possessory security, where effectively you hold an asset passively as a way of securing your interest, and then you release that when you're paid. You'll see that the definition of charge includes a mortgage, a fixed charge, and a floating charge. And there's an important distinction to be drawn there between a fixed charge and a floating charge. Generally speaking, a floating charge covers assets that are in flux, such as book debts, and crystallizes upon the occurrence of certain events. The distinction for the purposes of BVI insolvency is less important than in some other jurisdictions. So, for example, in England, you will see that a lot of store is set by trying to ascertain whether or not a charge is fixed or floating, because it affects the sums that can be claimed by liquidators, for example, in winding up a company, and it affects priority. Generally speaking, fixed charges rank higher than floating charges. However, in the BVI, the distinction is less important, and for example, a properly registered floating charge containing a negative pledge will normally run in priority to all subsequent fixed charges. And you'll see there, finally, that the most common form of security in the BVI are equitable mortgages or charges granted over shares in BVI companies. Just pausing there, a mortgage, generally speaking, is a form of security that is achieved by conveying the underlying asset with what's known as an equity of redemption. Normally, they're legal in nature. You generally have equitable mortgages where perfection has not taken place, or where the underlying asset is of an equitable nature. So in the BVI, mortgages are often taken over the beneficial interest in shares, and that's why they tend to be equitable in nature. So with that, I will hand over to Shane, who's going to talk about security and enforcement in the BVI.
Okay, thanks, David. So as David mentioned, the common form of security we see in the BVI is an equitable share charge. And the requirements of the charge are set out in the BVI Business Companies Act, section 66 there. The requirements are that it must be in writing, signed by or with the authority of the shareholder. Otherwise, there need not be any specific form or formality, but the charge must clearly indicate the intention to create a charge and the amount secured by the charge or how that amount is to be calculated. So the share charge can be governed either by the law of the BVI or a foreign law, where the governing law of the charge of the shares in a company is not the law of the BVI, then the charge needs to be in compliance with the requirements of its governing law, that is the foreign law, in order for the charge to be valid and binding on the company. And the remedies available under the charge are governed by the governing law and the instrument creating the mortgage or charge. Where the governing law of the charge is the law of the BVI, then there are two principal remedies available, and those are, as we've set out on the slide there. So subject to any limitations or provisions to the contrary in the instrument creating the charge, there's the right to sell the shares. And the second principal remedy is the right to appoint a receiver who, subject to any limitations or provisions to the contrary in the charge, can vote the shares, can receive distributions in respect of the shares, and can exercise other rights and powers of the chargeor in respect of the shares until such time as the mortgage or charge is discharged. In the case of a BVI law, a governed charge, unless the charge specifies that the charge is enforceable immediately upon default, the statutory remedies are not exercisable until a default has occurred and continued for a period of not less than 30 days, or such shorter period as may be specified in the charge, and the default has not been rectified within 14 days, or such shorter period as may be specified in the charge, from service of the notice specifying the default and requiring the rectification thereof. So if we turn then to, I guess, the principal remedy, which is generally used by secured creditors in the BVI, and that is the appointment of a receiver. So the receiver need not be a BVI licensed insolvency practitioner, although in practice we find it's usually beneficial for the receiver to be a BVI IP, particularly given their knowledge of the statutory regime and the powers that are available to them under the Insolvency Act. The Act does prescribe certain people from acting as a receiver. Those include mortgagees of the company, shareholders of the company within the previous 2 years, bankrupts, auditors or directors of the company within the previous 3 years, or body corporates. So the person you appoint as a receiver does have to be an individual. So unless the charge under which the receiver is appointed provides otherwise, a power to appoint a receiver includes the power to appoint 2 or more receivers, and joint receivers may act jointly or severally. So they can effectively make their decisions together or by themselves. What we commonly tend to see in the BVI is the appointment of a local BVI insolvency practitioner, together with an insolvency practitioner in the jurisdiction in which the company's assets or principal business is located. In terms of the formalities we've set out there on the slide, the appointment of the receiver is required to be made in writing and is not effective unless the receiver accepts it before the end of the next business day following the day on which the receiver receives the written appointment. So again, what typically tends to happen is that you'll have a formal deed of appointment signed by both the appointor and the receivers. In addition, immediately upon appointment, the receiver is required to send a notice of his appointment to the company and file a notice of appointment with the registrar of companies. It's probably also worth adding that the receiver is remunerated in accordance with the terms of the charge or as agreed with the person who appointed him. And this is usually out of the assets over which he or she is appointed. Although the receiver will often require some form of contractual indemnity from the appointor should the assets in his or her hands prove insufficient to meet his or her costs at the end of the day. So you'll see there that in a receivership, the company and its officers are required to cooperate with the receivers by making available to the receiver all books, documents, and information relating to the assets in respect of which the receiver has been appointed in its or his possession or under its or his control. If required to do so by the receiver, to verify by statutory declaration that the books, documents, and information are complete and correct, and give the receiver such assistance as he may reasonably require. In terms of the powers conferred upon the receiver has the powers expressly or impliedly conferred on him by the charge under which he was appointed, and this will most usually include a power of sale. So unless the charge expressly provides otherwise, a receiver may also exercise a number of statutory powers, including to demand and recover, by action or otherwise, income of the assets in respect of which he was appointed, issue receipts for income recovered, manage, insure, repair, and maintain the assets in respect of which he was appointed, and exercise on behalf of the company a right to inspect books or documents that relate to the assets in respect of which he was appointed in the possession or under the control of a person other than the company. As regards a receiver's general duties, his primary duty is to exercise his powers in good faith and for a proper purpose, and in a manner he believes on reasonable grounds to be in the best interest of the person in whose interest he was appointed. To the extent only that it is consistent with that primary duty, a receiver is also required to exercise his powers with reasonable regard to the interests of the company's other creditors, sureties who may be called upon to fulfill obligations of the company. So, for example, guarantors of the company's obligations, persons claiming through the company an interest in assets in respect of which he was appointed. So, for example, there you might have subsequent holders of subsequent security over the same assets. And then lastly, the company itself. And perhaps not surprisingly, a receiver who exercises a power of sale in respect of assets over which he was appointed owes a duty to obtain the best reasonably obtainable price at the time of sale. So that deals with the principal remedy of the secured creditor. So what then are the options for an unsecured creditor?
Shane, just pausing there for a moment. I think there's a bit of an echo, I'm told, on the line. I'm not sure whether that's your machine or, I mean, I think everybody else is on mute.
Okay, yeah, I'm not sure what more I can do about that. Is that any better?
Okay. I think that's better. Yeah.
Yeah, this might challenge my technical skills by holding this microphone to my mouth while I work the slides as well. So in terms of unsecured creditors, as we say there are generally two options. The first is to bring a claim or court proceedings against the company, or secondly, to apply to appoint a liquidator to the company. So the primary consideration in deciding which option to pursue will be whether the company is believed to have sufficient assets to discharge the debt. If the company does have sufficient, or does not have, sufficient assets to discharge the debt, or those assets are heavily secured in favour of other creditors, or it is believed that the debtor may already have attempted to make itself judgment proof, then there might be little worth in pursuing legal proceedings against the company. If, however, you do decide to pursue a legal claim against the company, then the first thing to consider when bringing a claim is the question of jurisdiction. So you first need to consider whether the BVI court is the appropriate court before which to bring your proceedings. So the BVI court does have personal jurisdiction over companies incorporated in this jurisdiction. But you may well find, for instance, that the contract on which you wish to sue has an exclusive jurisdiction clause in favour of the courts of another country, in which case you may well have to go to that particular jurisdiction to obtain the judgment you seek. Otherwise, assuming that the BVI court does have jurisdiction, and just by way of brief overview, the claims procedure is as follows. You commence your proceedings by issuing a claim form and statement of claim, in which you set out the nature of your case and the essential facts rather than the evidence upon which you rely. The claim is then served on the company. The company will have 14 days in which to acknowledge service, and provided that it does acknowledge service, it will then have a further 14 days in which to file a defence. If the company fails to acknowledge service, or it does acknowledge service but then fails to file a defence, it is possible to request the court office to enter default judgment against the company. So default judgment, or the entry of default judgment, is an administrative act which does not actually require a court hearing. Although if the sum being claimed is in the nature of damages, it might be necessary to have a subsequent hearing before the court to have the quantum of those damages assessed. The company would have an opportunity to be heard on the question of quantum, but not then on the question of liability, which itself is settled by the default judgment. Alternatively, it may be possible to apply for what is known as summary judgment if the company does file a defence, but you can show that the company has no real prospect of successfully defending the claim. That involves a hearing before the court, at which the court will consider the substantive merits of the defence. If the claim is otherwise defended on arguable grounds, then the matter may need to proceed to a trial, which will take place some months after the issue and service of the claim form, after the completion of a number of interim or interlocutory steps, such as, for instance, disclosure of relevant documents by both parties and exchange of witness statements and the like. So if there is any concern that the company or the defendant is attempting to judgment proof itself in response to or in anticipation of the claim, it may be possible to apply for what is known as a freezing order. A freezing order is a form of injunction that restrains a defendant from disposing of or dealing with its assets, other than in the ordinary and proper course of business. Its primary purpose is to prevent the dissipation or concealment of assets that would otherwise be available to satisfy a prospective judgment. In order to obtain a freezing order, you need to be able to show two things essentially. The first is a good arguable case. That is one which is more than barely capable of serious argument, and yet not necessarily one which the judge believes to have better than a 50% chance of success. And secondly, a risk of dissipation of assets. Risk of dissipation is established by showing that there is a real risk that the judgment will go unsatisfied, in the sense of a risk that, unless restrained by injunction, the defendant will dissipate or dispose of its assets other than in the ordinary course of business, or that unless the defendant is restrained by injunction, assets are likely to be dealt with in such a way as to make enforcement of any judgment more difficult, unless those dealings can be justified in the normal and for proper business purposes. So solid evidence of risk of dissipation is required. Allegations of dishonesty are generally insufficient unless that dishonesty goes to the heart of the claim and can be established to the necessary standard.
Just before Carly continues with the rules governing the first meeting of creditors, can I just invite everybody, if you have any questions, to use the chat facility, and we'll do the best that we can to answer that. Over to Carly.
Excellent, thanks, David. I'm going to be speaking about the first meeting of creditors subsequent to the commencement of liquidation proceedings. Now, the overriding purpose of the first meeting of creditors is to give the creditors an opportunity to protect their position by attending and voting at such a meeting, either in person or by representative. So let's assume that you are a creditor and you've received a notice to attend the first meeting of creditors. It may well be that you were yourself the petitioning creditor and in a court-ordered compulsory liquidation, or you received a notice subsequent to an order where the petition was filed by another creditor, members or directors of the company. Now, this was covered in the first webinar of the series, but that's known as a winding up by the court. So that's a compulsory liquidation. Or you may have received the notice as a creditor after the shareholders pass a qualifying resolution to place the company into liquidation. In this instance, it's referred to as a creditor's voluntary liquidation, and this is a director-initiated process rather than a court-ordered compulsory liquidation. So generally speaking, this procedure at the first meeting of creditors is the same, irrespective of the insolvent process which was followed. So once the company is in formal liquidation, whether it was by court order or by resolution, the liquidator must call a meeting of creditors, and this is generally referred to as the first meeting of creditors on at least 14 days notice within 21 days of his appointment. Now that notice must be sent to each known creditor. So the liquidator may have already received a statement of affairs or have the books of records, and he'll have a record of who the creditors are. But in addition to sending it to each known creditor, he has to advertise that notice of his appointment together with a notice of the meeting. Now that advertisement will be published in the BVI Gazette and the BVI Beacon. And now the aim of the first creditors meeting is really for creditors to answer two very important questions. Firstly, do they want to replace the existing liquidator with a liquidator of their choice? And this will generally happen in instances where there is another creditor who has appointed the liquidator, or the liquidation was commenced by resolution by the directors or members. And then secondly, the second question that creditors must ask themselves when attending a first creditors meeting is whether or not they'd like to establish a creditors committee, and if they do, who they'd like to serve on that committee. So who is entitled to vote at a creditors meeting? Creditors may vote at the meeting only if they've lodged proof of debt and, if necessary, a proxy. A simple majority is required to pass a resolution. So that is a majority in value of those present and voting in person or by proxy. And the quorum for creditors meeting is at least one creditor who must be present or by proxy. Now, whilst the main purpose of the first creditors meeting is to, as I mentioned before, ratify the appointment of the liquidator and to determine whether a creditors meeting must be established, if the liquidator was appointed by members, and generally speaking in practice as well, the liquidator will, at this first meeting of creditors, report to creditors on the actions that he's taken since his appointment. So remember, this is within 21 days of his appointment, so it really is the early days. And generally speaking, he won't have a lot of information, but he will give creditors a background of his appointment, the reasons why the company is in liquidation, the actions taken by him to date, for example, filing the notice of his appointment with the registry, advertising the appointment, if he's made contact with any creditors, the amount of claims that he's received, whether he's in the process of reviewing it, or accepting or rejecting it, and whether he's obtained the books and records of the company, and whether he has sent a request for and obtained the statements of affairs from the directors. Now, if he has obtained those documents relating to the financial affairs of the company, he may at that stage give the creditors his preliminary findings as to the assets and liabilities of the company, as well as the claims that he's received to date. So it really is a general feedback session, but most importantly is the ratifying his appointment, and as well as determining the establishment of a creditors committee. Thanks, Shan. I think you can go to the next slide, formation of a creditors committee. So what is a creditors committee? A creditors committee is a group of people who represent the body of creditors in insolvency proceedings. Now, the overriding purpose of a creditors committee is really to assist the liquidator in the administration of his liquidation duties and to monitor proceedings. So this could involve helping the liquidator to make key decisions, for example, whether or not he should take legal action to recover assets. And it's important to note that the liquidator should always take into account the views of the committee, but he's not obligated to follow their wishes. So that they're a counsel to them, but he's not obligated to follow their wishes. Now, a creditors committee is voluntary work to assist the liquidator. Members of the committee are not paid for their time acting on the committee, and being a member of the creditors committee will not promote the ranking of their debts. So how is a creditors committee established? So creditors may pass a resolution to establish a creditors committee at any time after the appointment of liquidator. In practice, that would generally occur at the first meeting of creditors, as we discussed earlier, or at any time thereafter by a meeting requisitioned by at least 10% in value of the creditors of the company. How it is composed, the creditors committee must consist of not less than 3 members and not more than 5. So if the company only has 2 creditors, a creditors committee cannot be established. Or if there are more than 5 creditors who have expressed an interest to serve on the committee, there must be a vote among all the creditors as to who they prefer to be serving on the committee. And only those individuals who are, number 1, a creditor and whose claims have not been rejected and who has consented to writing are eligible to be appointed as members of the creditors committee. Once a creditors committee has indeed been established, then a notice of that establishment must be filed with the court, and that notice must specify the name and addresses of the members of the creditors committee. The functions and powers of a creditors committee. So a creditors committee is really there to consult with the liquidator about matters relating to insolvency proceedings. The committee may require and request regular updates on matters and may seek guidance and in some instances formal approval for specific courses of action. That will typically occur when creditors are funding the liquidation. They might request approval for certain actions. They are there to review the actions of the liquidator, and they may require him to report to the committee by giving him not less than 5 business days notice. They're also there to assist the liquidator in discharging his functions. They may provide the liquidator with the benefit of specialist knowledge, either about the company or the industry in which the company operates, or they may agree to fund the cost of the liquidation before assets are realized. They also have the power to call creditors meetings. And very importantly is they have the power to remove a liquidator. Now, Lisa will be discussing this more in detail in her presentation, but just to note for the purposes of the powers of a creditors committee is that they are one of the qualifying parties who may make an application to court to remove the liquidator in terms of section 187(2) of the Insolvency Act. And Lisa will elaborate on that a little bit later. And then finally, the creditors committee approve and determine the remuneration of the liquidator. In particular, the Creditors Committee must approve the basis of calculation of the remuneration of the liquidator. So if there is no Creditors Committee, the liquidator must make an application to court to fix his fees. There's a utility in having a Creditors Committee, even from the liquidator's perspective. Finally, on the purposes of a Creditors Committee, serving on a Creditors Committee can give creditors the opportunity to have a positive impact on the insolvency process and could assist the liquidator to maximize returns to creditors and providing essential information and knowledge which could assist in tracing company assets which have been misappropriated or identify conduct by the directors which could ultimately lead to their disqualification. Thanks, David. I think that's all from me.
Thanks, Carly. I think Lisa, as you foreshadowed, is now going to talk about the removal of liquidators under the Insolvency Act and rules.
So today I'm going to be talking about what creditors can do once the liquidator has been appointed. What I'm going to be talking about is quite technical and quite wide-ranging, and I'm only going to be doing it at a fairly high level. So if anybody's got any questions either during my section or afterwards, by all means, get in touch. There's going to be 3 sections of the Insolvency Act that I'm going to refer to, and they are removal of a liquidator, amending admitted claims, and general challenge to the decision of a liquidator. There may also be other remedies available, but they're for another day and require a bit more in-depth consideration. I suppose the top piece of advice that I can give if you're facing a challenge or you want to make a challenge is get specialist legal advice as early as possible, as it is quite a tricky area. But it's important everyone has a bit of an idea about the remedies available to a creditor. So under Section 187 of the Insolvency Act 2003, the court may, on an application by a person specified in subsection 2 or on its own motion, remove the liquidator of a company from office. It's more usual there's an application rather than the court suddenly decide to remove a liquidator itself. Certainly I've never seen that in the 20-odd years I've been doing insolvency work. So who can apply to remove a liquidator? As Carly's already identified, one of the parties that has specific standing to make such an application is the Creditors Committee. In addition, a creditor or the member of a company or the official receiver can also make an application. However, in the 1990 case of Corbyn Stroke, it was held that where it is an insolvent liquidation and there's not going to be any return to the members, it's unlikely that a member would have standing to make an application. The rationale being they don't have any interest in who the liquidator is if they are not ultimately going to recover anything out of the liquidation. So the next thing to consider is when will a liquidator be removed? And Section 187 has 2 parts to it. Part A provides that a liquidator will be removed if he or she is not eligible to act as an insolvency practitioner by reason of any breaches of duty or obligation imposed on him or her or owed by him or her under the Act, the rules, or any enactment in the Virgin Islands. And thirdly, that they fail to comply with any direction or order of the court made in relation to the liquidation of the company. And it's important to remember that there remains a discretion of the court to remove a liquidator, save I would say in relation to A1, because if an insolvency practitioner is not eligible as a matter of law, that would override any discretion. The more important part, and the thing you come across more often, is subparagraph B, and that's where the court may remove a liquidator where the court is satisfied that the liquidator's conduct of the liquidation is below the standard that may be expected of a reasonably competent liquidator. The liquidator has an interest that conflicts with his role as liquidator, or that for some other reason he should be removed as a liquidator. So that's all to do with factual allegations with regard to what a liquidator is and isn't doing. And it's an expansion of the old principle that appeared in the various different Companies Acts around the world of due cause. So there has to be a reason for somebody to be removed. So the next thing to consider is when will they be removed and what the courts have had to say about this. There's a really helpful authority that I set out there called Fundora against Hamilton Smith, which is actually an Antigua case, but it does contain consideration of over 25 different cases from many common law jurisdictions where the concept of due cause and satisfactory behaviour were considered by the court in some detail and to draw a conclusion when there is due cause. The conclusion of the Antiguan High Court, as has been affirmed in the Eastern Caribbean Supreme Court in the Court of Appeal, dates back to, it's a 19th century principle, and that's set out on the slide. And you'll see that in Adam Ayton, it was said, and it remains the case now, the jurisdiction of the court to remove a liquidator under sections 93 and 141, in this case, section 187, on due cause shown, is not confined to cases where there is personal unfitness in a liquidator. Whenever the court is satisfied that it is for the general advantage of those interested in the assets of the company that a liquidator be removed, it has power to remove him and appoint another one. So the upshot of that is you don't have to prove dishonesty, misfeasance. There can just be a combination of factors that mean that it's no longer in the interests of the liquidation for the liquidator to continue in post. In the Fundora case, there were 9 separate allegations that were set out against the liquidators that ranged from destruction and mishandling of computer data and evidence, acting outside of their remit, efficiency of the liquidators, failure to continue, the credibility of the liquidators, and support for the retention or removal of the liquidators. The court will consider each of the allegations in turn and make a decision as to whether they consider they have been proved. And the things the court will take into consideration is, amongst other things, misconduct, although it's not necessary, the standard of proof, which is the usual civil standard of proof, the level of skill required, that's set out in section 187, it must be a competent liquidator. And the court does have a duty to remove a liquidator in appropriate cases. It will have regard to the wishes of creditors, because after all, a liquidation is being conducted, certainly an insolvent liquidation, for the benefit of the creditors. But also the court will balance that with the cost and delay of the removal of a liquidator. So one of the other things the court will take into consideration it has to carry out a balancing exercise. In particular, primary thing, as was held in AMP Music Box, another case referred to on the next slide, is that the court has a wide discretion whether or not to remove and replace liquidators. So even if due cause is found, it will not necessarily remove a liquidator. It will only remove a liquidator on good grounds, and it is incumbent upon the person seeking the order to establish those grounds. Whether those grounds are established will depend on the particular facts of a particular case. And in general, the court will not lay down what facts will and facts will not constitute sufficient grounds. So in the Fundora case, going back to that, the court found that all 9 grounds of challenge, taking each one into consideration and putting them into the general balance, the court concluded that there was due cause. It then went on to consider whether, in fact, the court should remove the liquidators. And in that case, relying on an earlier decision, it said it's quite clear from the entire time of authority stretching back to 1867 that in appropriate circumstances there may be good cause to remove a liquidator, notwithstanding the failure of the applicant to prove misfeasance, even though no reasonable criticism can be made of his conduct. And in the Fundora case, the court considered that the allegations, when taken together, were sufficient for the removal of the liquidator. So it's very much facts-based. It will depend on the particular circumstances. Other examples of liquidators being removed are where a liquidator did absolutely nothing. But equally, on other cases where the court has found the liquidator's not done very much, the court's considered that that's sufficient to prevent removal. So it's something you do need to think about quite carefully. The only other thing that should be borne in mind is that under Insolvency Rule 175, this governs what has to be in an application to remove a liquidator. And such an application will be held in chambers, in private, and the court may require an applicant to make a deposit or provide security for the costs of such an application. But in any event, the costs of an application to remove a liquidator will never be borne out of the estate of the company. They will either be paid by a liquidator, assuming he's removed, or alternatively, if the application is unsuccessful in following the usual rule, the applicant would be bearing the costs of such an application. So it's important to bear in mind if it's something that you might in future want to pursue. The next section I'm going to deal with very briefly. It's only a very small section, and it's not one that's really used terribly often. And it's section 210 together with Insolvency Rule 186. So section 209 sets out how a claim in a liquidation will be made. And under section 210, subsection 1, that may be withdrawn by the creditor at any time before it is admitted, or once it's been admitted, it can be withdrawn or amended at any time by agreement between the creditor and the liquidator. So section 210 goes on to provide that the court, on the application of the liquidator, or where the liquidator declines to make application under this section, a creditor may expunge or amend an admitted claim if it is satisfied that the claim should not have been admitted or should be reduced. So that allows for a third creditor who is not happy at the amount being admitted by the liquidator, or the fact that the claim has been admitted at all, to apply to court and to prove that it should not have been admitted on good grounds, or that the amount that's been admitted is incorrect, it should be reduced. It's important to note that this section cannot be used where a creditor is unhappy at the level of its claim, where it wants the level of its claim increasing. That would have to be a claim under the next section, challenging liquidators' decisions, and that is under section 273. The only other thing to note on section 210 is that under Insolvency Rule 186, any such application must be served on the creditor whose claim is being challenged, and where it is an application by a creditor, it must be also served on the liquidator. So section 273, this is a very short section. It's worth taking it into consideration on this slide. It provides that a person aggrieved by an act, omission, or decision of an office holder may apply to the court, and the court may confirm, reverse, or modify the act, omission, or decision of the office holder. So it's an office holder, so it's broader than just liquidators. That's something that's worth bearing in mind. It is very wide-ranging, and it relates to all decisions of a liquidator. I've touched on challenges to claims, but it can be anything. However, the court will not interfere lightly with the decision-making processes of an office holder. For example, in relation to a decision to commence or continue bringing or defending claims, to the value attributed to the sale of assets, and whether or which professional advisors to instruct. These are all challenges that have been brought over time. And the court will not interfere lightly with those sorts of decisions. The court recognises that the liquidator has a job to do in balancing the conflicting needs of the liquidation, including the costs that may incur in pursuing a course or not pursuing a course, whether such a course of action is in the best interests of the liquidation as a whole. So the court will not generally interfere. So who can apply to challenge a liquidator's decision? So in Stamford and Acres, which is a decision of the BVI Court of Appeal, it is a requirement that the person aggrieved be a contributory, a creditor, or a third narrow class of persons directly affected by the exercise or non-exercise of a power specifically given to liquidators who would not otherwise have any right to challenge the exercise of that power. The court that is asked to exercise a statutory power or its inherent jurisdiction will act only on the application of a party with sufficient interest to make it. So there's your first hurdle. The first hurdle is, are you actually in a position to make an application? Are you a person aggrieved, or do you fall into one of the identified categories? So, for example, an application by the shareholder of a wholly owned subsidiary of a creditor does not have any standing to make such an application under Section 273. It is a very narrow group of people, but obviously right in the middle of that, what we're talking about today is quite clearly a creditor has a right, and rightly so. So what will the court consider an appropriate decision or omission or act to challenge? There's been a lot of authority surrounding the use or non-use of Section 273, and even as recently as the last couple of weeks, Mr. Justice Jack in the BVI court confirmed, and in fact it was confirmed by the Court of Appeal in Stamford and Acres, that the proper test is what's called the Perversity Test. And that's derived essentially from a case called Eden Note that dates back to 1996. And it's quite clear that the court will only interfere with the act of a liquidator if he has done something so utterly unreasonable and absurd that no reasonable person would have done it. So you can see that's a pretty high bar to get over when it comes to challenging a decision of a liquidator. And it is usually pretty difficult to get over that test. Quite often in courts we talk about, in applications we talk about reasonableness and unreasonableness, and the most famous test of unreasonableness is something that derives out of administrative law called Wednesbury unreasonableness. And in Rayner Bush and Mercury Partners, the BVI Court of Appeal in 2018, although it's a 2014 case, held that the test is much higher than the usual Wednesbury unreasonableness test. It is something not just that no reasonable person properly directing themselves would have made the decision. It's that only somebody who was essentially out of their mind could possibly have made the decision. There are, however, two exceptions to that. The first is well established from 1998 and has been upheld in the BVI Court of Appeal, and that is where there is a question of law, such as in the Mitchell and Buckingham case, the efforts of a judgment creditor to put themselves in the position of secured creditors before the moratorium as a result of a liquidation. That is a matter for the company's court or for the liquidators acting under the control of the company's court. So where the court's being asked to determine a question of priority or a matter of legal interpretation of a contract, etc., then that would be something that the court would apply the usual civil standard of proof rather than the absurdity, perversity test. In Stavanovich and McDonald, Mr. Justice Wallbank, again in about 2017, although it's a 2013 case, said where there isn't the issue is whether the claim should have been admitted. And he went on to say that that would include in the amount it was admitted or in a larger sum. That is a question of law as to whether it is a provable debt and is an exception to the perversity test. So looping back to Section 210, any application under Section 210 to reduce a claim and any application under Section 273 to increase a claim would be subject to the normal standard of proof rather than the exceptional perversity test. So I hope everyone's enjoyed that whistle-stop tour on challenges to the decisions of liquidators. And anyone got any questions for any of us?
I was about to say thank you to all the panelists. It appears that we finished within time with 5 minutes to go. I think it was very much a helicopter tour of subject matter. There's subject matters that could, I think, occupy several volumes of books and hours of lectures. So I think the overriding message to take away is if you've got any questions, then please do ask us. And if there are any of these issues that arise in your professional practice and you're not a lawyer, then obviously take advice on them. We have 5 minutes. I see actually somebody has just put forward a question. So if I can open it. No, we were just talking about the echo. If anybody's got any questions at all, please do feel free to answer them on the question and answer or chat function, and we'll take them now. Well, I think we've answered the issues so succinctly that nobody has any questions at all. Please do feel free to get in touch with us if you do have any questions, and we'll do the best that we can to answer them independently or together at a later date. Thanks very much for your time.